And once you get the final statement done, you might have several versions of the statement, because you might say, "Did you change this and did you change that for me?" And then you'll get a second version sent back to you with some of the amendments in it. You might do everything you asked or some of what you asked. You can go back and forth several times if you wish, or you can simply get the statement finalised. You can finalise it on day one if you want, and just lodge an appeal if you want to speed the process a wee bit. But usually you can sort it out through that consultation process equally. Once you've got the final statement, only then do you have access to appeal rights, and you've got 2 months to make an appeal to the Special Needs Tribunal, and it's quite a strictly applied time limit of 3 months. There's the reason for which you can make an appeal, and it's all based around the stages 4 and 5 of the code of practice. So if you refuse a statutory assessment, if you refuse a statement, you get a vote of no of the statement. If you're not happy with what's in Part 2, special needs, Part 3, provision, or Part 4, the name of the school, you can appeal. If any part of your statement is amended, it opens the whole statement up to appeal as well. So sometimes you might try to get it amended just to get it open for an appeal. You can get a small amendment made. Refusing to amend after a reassessment, that's a statutory reassessment, not just a review of the child, but an actual statutory reassessment. Refusal to change the name of school if the parent requests it, or if the statement is ceased or stopped, you already appeal, and pending that appeal, that statement continues to operate. So there's a safety net there if anyone wants to say. It doesn't happen that often, but if they were to cease the appeal, you would have that safety net
Say your
there.
child is going through the statement process, it comes out that they aren't able to stay in mainstream.
Yeah.
Can you appeal that you want
Yes.
them to stay in
Yes.
mainstream?
SENDO gives you a strengthened right for a child with disability to attend a normal school or mainstream school, as long as that doesn't affect the efficient education of other children. It's essentially the test. So if the school is able to manage that child along with the other children in the mainstream class, or to make reasonable adjustments to ensure that child can be educated in the mainstream class, your child should be able to go to mainstream. There are some cases where mainstream is just not suitable, in which case the child may need to go to a special school, but parental choice is actually enshrined in the law, and you have the right to state your preference as a parent, and the barriers to the education authority in refusing parental choice are quite high, so they have to be able to show that the school really can't meet the child's needs and the other children's needs in the class.
Extreme circumstances where they would take a child out of mainstream
Yes,
and put
yeah,
them
they'll
in
have
a special needs.
and there'll be no process of consultation around that. It can't just be done like that. It will have to be parents have to be consulted, and other professions will have to be consulted as well. It's a big decision to change from one type of school to another, so everyone needs to be involved in that. So as I say, it's 2 months time limit for sending appeal. Don't miss the vote. And if you're making a claim for disability discrimination, it goes to the same tribunal. So if your child is not treated less favorably than other children, or if they have schools failed to make reasonable adjustments to ensure quality for your child, or if the education authority has refused to make adjustments for your child to ensure they can attend school or something like that, which may be discrimination, then there's 6 months to make a claim for disability discrimination. There's no monetary compensation for such a claim, but you can get a declaration of disability discrimination, and staff training and apologies and that sort of remedy from that tribunal. Often the SEN appeals and discrimination claims are intertwined, the same facts are involved in both, in which case they can be heard together.